Hello everyone, my name is Paweł Jędrysiak. I'm the PhD student from University of Silesia in Katowice in Poland. And first of all, I would like to thank you for the opportunity of being here and present my speech in front of you. I would love to thank the organizers of the conference and all of the attendants. The main topic of my speech is the international protection of intellectual property goods in the light of the European legislation. But first of all, before we start our deliberation on the protection of intellectual property rights, we should ask ourselves the question: what is intellectual property? What exactly that means? According to the general point of view, intellectual property is considered to be a product of human creative work, which, due to its uniqueness and high economic or development importance, deserves protection. Therefore, we call intellectual property everything that has been created by human with the help of his or her intellect and it's innovative and original. The intellectual property rights is therefore the total of exclusive rights granted to authors for the creation of intellectual property by them. These rights comprise two categories of rights. The first is the industrial property law, which includes regulation on the protection of inventions, the trademarks, industrial and utilities design, or for example, geographical indications. The second category is copyright, and here I'm sure that all of you heard about the copyright, and and I think that most of you know what does it mean. But to point it out, the copyright protects all manifestation of human creative activity of the individual of an individual nature which have been established in any form. So, for example, copyright protects songs, the poems, the paintings, and even, for example, the architecture works. And even our presentation, for example. Sometimes the concept of intellectual property also includes the database, know-how, and personal rights of a person. As part of this paper, however, I would like to focus mainly on copyrights, law, and industrial property rights. Intellectual property law is regulated at the national level by each member state of the European Union. Special provisions governing such powers are also provided for in international law. Nevertheless, intellectual property law is also subject of European Union legislation. That is obvious because without that, my presentation wouldn't have any sense. The most important article about the intellectual property law in the European Union level is probably the Article 118 of the Treaty of the Functioning of the European Union. Pursuant to this article, as part of the creation and functioning of the international market, Parliament and the Council, in accordance with the ordinary legislative procedure, take measures on European Union intellectual property law to ensure uniform protection in the European Union and to set up centralized European Union authorization, coordination, and surveillance system. All activities of the European Union related to the creation of the intellectual property rights are focused on harmonization certain aspects of intellectual property rights in its own system. I think the best example could be here trademarks. About the trademarks, I will say something more later, but now I want you to know that trademarks are among the most regulated areas of intellectual property at the European Union level. The European Union has introduced a community system for the protection of European trademarks, which allows registration of this type of designation in all member states with only one single application. Intellectual property protection instruments in the European Union largely reflects the international obligation of the member states under the Berne and Rome Conventions, as well as the Agreement of Trade-related aspects of intellectual property, which is annexed to the Agreement on the establishment of the World Trade Organization. Take care of intellectual property contributes to the development of the entire economy and the individual European entrepreneurs. The European Parliament plays the extremely important role in the harmonization of intellectual property rights, engaging in the creation of the uniform system of protection of these rights, which would be binding in all member states. The European Parliament also takes important decisions regarding the development of intellectual property rights. For example, Parliament is in favor of harmonization of rules on the protection of date-based biotechnological inventions and copyrights. It is, on the other hand, opposed to the patenting all kinds of inventions, which includes, for example, the parts of the human body. An example of Parliament's intensive activity should also be its active role in drafting the WIPO Treaty on copyright exceptions for the visual impaired. The body appointed to administer intellectual property resources in the European Union is the European Union Intellectual Property Office. This office is really important because it manages all kind of European trademarks, and also it's a watch for some kind of violation of the European intellectual law. But the development of the intellectual property protection policy has been gaining importance in the recent years. Nevertheless, the rapid development of technology and the increasing commercialization of intellectual property goods means that many issues have not yet been sufficiently or not regulated at all at the European level. And the great example of that is artificial intelligence. One of the intellectual property problems that results from the technological advance is works created by artificial intelligence. Technological progress determines the question of whether works that have been created or generated by artificial intelligence products can be protected by intellectual property law. According to the current view, in order for a work to be protected, it must be created by human as a result of his or her intellectual effort. However, technology that develops faster and faster is questioning this premise. In the case at hand, the European Commission takes a position that artificial intelligence should not be treated as the subject of rights, and therefore works that have been generated by artificial intelligence should not be protected. This position is consistent with the position presented by European Patent Office, which refused to grant patent protection to innovations created or maybe more generated by artificial intelligence. In my private opinion about this is that I agree with that position of the European Union bodies, because in my opinion and as a practice, I see that only human being can be is able to make some kind of creative process. This type of artificial intelligence can do something only in mechanical way. So it's not the creative process, and the results of this process shouldn't be protected by, for example, copyright. Nevertheless, despite the uniform position of the European Union bodies and my private opinion, there is a noticeable legal gap as regards the harmonization of law in this area, because it is really necessary to regulate separately the issues related to products which was generated by artificial intelligence and these that were created by human, only supported by artificial intelligence. The second problem that I would love to tell you is technology of blockchain. I'm sure that you also heard something about the blockchain technology, but I think that uh, you don't think about the blockchain technology in aspect of the copyright law, because the blockchain technology is mainly associated with the storage of data and transactions related to cryptocurrency. As it turns out, however, they are also used in the intellectual property protection sector. Some startups introduce the possibility of registering information about the songs on the blockchain. This information is stored on the blockchain network in a way that makes it almost impossible to influence it, of course, influenced by the third parts. Thanks to this type of procedure, blockchain technology can make it easier for the creator to search for potential violation of the plagiarism of their works. In addition, registration of this type of international might serve as evidence to the authorship of the specific work. Such use of this type of the technology would significantly facilitate the pursuit of claims related to infringement of property copyrights. An undoubted difficulty in the use of this technology, however, is the need to register information about the artworks. Because it should be remembered that copyrights to works are created regardless of their registration anywhere. So if I make some kind of artwork, I don't have to register that one to have a protection of my work. But however, if properly refined, this system could make a significant contribution to the reducing the circulation of the counterfeit goods and preventing to the spread of plagiarism. Unfortunately, in the current system of affairs, the bodies of the European Union are not taking steps to regulate the issues related to the use of this technology to protect the intellectual property rights of European creators. Another issue that I would like to point out is indirectly related to the protection of intellectual property, but it is the issue of the transmission of esports games, I mean electronic sports games. It could potentially seem that the broadcasting of esports events should be regulated in the same way as the broadcasting of any other sport events. Nevertheless, it should be noted that computer games, which are works protected by copyrights, I mean artworks protected by copyrights, are an inseparable tool for the implementation of this type of competitions. It should be noted that the very concept of the computer game is quite controversial in terms of copyright. Each game consists of both a computer program and other elements that are not part of the computer program, such as, for example, the graphics, music, or even a plot. On the other hand, taking into account the computer programs are subject to special protection and are subject to a separate legal regime. Their classification, because of that, is significantly difficult. Until now, European Union legislation has not specifically regulated the copyright protection of computer games as such. Bearing in mind the above, it should be noted that the issue of broadcasting esport games with consists in playing computer games in the current time is a special issue that should be regulated at the European level. A lack of registration in this regard might contribute to the inhibition to the stopping of this branch of sport, and makes a lot of trouble for all of the players, for example. What is really fascinating, because European Union don't have a special regulation about that, but for example the Korean got something like that, got a special special regulation about that, and I think that we should inspire by this country, and we should start thinking about make a new regulation about it in our European area. The last issue that I would like to mention in this speech are trademarks. Trademarks might be any sign that enables to distinguish the goods of one enterprise from the goods of another enterprise, and I think this is the best and the shortest definition. But also we have to remember that the trademarks can be have to be able to be presented in the register of trademarks in a way that allows for the identification of prices subject of the protection granted. Therefore, there is no doubt that the trademarks are have got a great economic importance for all entrepreneurs, including European ones. Classical trademarks are word marks and figurative marks. I mean, for example, it could be just short name of the company or some kind of logo. But however, with the development of marketing techniques, entrepreneurs began to use the so-called unconventional trademarks more and more often, including signs that are not specific through the sense of sight, such as, for example, taste or even a smell signs. These signs, due to their nature, are however more difficult to register than conventional marks, and I think this is also really obvious, because it should also be pointed out that the European Union authorities still prefer a conservative approach to the trademarks. This approach can be compared with, for example, with the trademark protection policy that is being implemented in the United States. This is because there is a significant liberalization of regulation on the registration of the unconventional marks. The European Union meeting the needs of entrepreneurs and in 2017 amended the provision on trademark in a way that was facilitate the registration of unconventional signs. However, as it results from the current practice of the European offices, the national offices, unconventional trademarks are still recently registered, mainly due to problems related to their exact definition in the applicable registers. There is no doubt that unconventional trademarks will become more and more popular in the near future. This, in turn, will determine the need to introduce new changes to the applicable European Union legislation. To sum up, I would just want to point out that bearing in mind the above consideration, it can be noted that the constant development of the technology will determine the introduction of new regulations regarding the protection of intellectual property in the European Union. Despite quite comprehensive regulation of issues related to copyright and industrial protection right, the current regulation do not keep up with the times and the current social development. But I hope, and I feel this is the hope of everybody, that it will change in the the nearly future. This would be everything from me. Thank you for your attention, and goodbye.